Hello everyone, I'm Dr. Kalpana. In this lecture, we will try to understand uh, Insolvency and Bankruptcy Code 2016 and would be providing a comprehensive overview of this code and would try to understand its origin, key provisions, impact on India's economic landscape. IBC has revolutionized the approach to insolvency resolution, aiming for time-bound processes and enhanced recovery rates. So before going to the code, I would try to make you understand what is insolvency and what is bankruptcy. Insolvency is a state where a person, company, or corporate is not unable to pay his debt, and bankruptcy is a legal process to address insolvency issues or state of insolvency. So bankruptcy is a process, whereas insolvency is a situation of being unable to pay the debt. So now, first of all, we need to know what is the need for IBC code, since we do have a lot of set of legislation like SURFACE, recovery of debt due to Banks and Financial Act 1993, SIC Industry Act also is there, Companies Act is also there. What is the need of bringing this separate code? Before 2016, India's insolvency regime was fragmented, insufficient, inefficient, characterized by multiple laws like Companies Act, SURFACE. This led to lengthy delays, averaging almost 4.3 years. That's an average of the disposing of the cases, low recovery rates, making it a creditor unfriendly environment. So creditor's right is supreme in law. So objective of IBC was introduced to consolidate insolvency laws, provide a time-bound resolution 180 to 330 days, balance stakeholder interest. Its goal include maximizing asset value, promoting entrepreneurship, and improving credit availability. The Bankruptcy Law Reforms Committee recommended this code. Uh, the first and foremost question comes to the mind whenever we talk about any law: applicability of insolvency and bankruptcy code. Corporate persons applies to companies, a limited liability partnership form under Part 2 of this code. Individuals and partnership forms covered under Part 3, not fully enforced. Persons guarantors notified for corporate debtors, extending IBC reach. Section 2 of IBC outlines its broad scope, ensuring the comprehensive framework for insolvency across various entities. This unified approach aims to streamline processes, enhance efficiency in resolution. There are some key definitions which needs to be understood under Section 5, corporate debtor. A corporate person who owes debt to any person is called corporate debtor. Insolvency resolution process, a process to resolve a state of insolvency of a corporate debtor. Would like to quote certain examples where recently a lot of real estate people declared insolvency and left the project unfinished. So there is a problem with the stakeholders like buyers, financial institutions, creditors, financial creditors, operational creditors, in such a manner that all stakeholders are in problem when insolvency situation arrives. So that has to be redressed. That's why we call it insolvency resolution process. Financial creditor, a creditor to whom a financial debt is owed, for example, loans, debenture, etc. Operational creditors is something they play vital role in making any project or any company formation, a creditor to whom an operational debt is owed, for example, a supplier, employee, rent, people who are supplying goods, services, etc. They help out, facilitate in their operations through different means instead of giving them liquidity. They are called operational creditors. Default, non-payment of debt when it comes due is called default. Debt includes both financial and operational debt. Now coming to part 2, corporate insolvency and applicability. Scope of Part 2, Section 6277 of IBC applies to companies incorporated under Companies Act, LLP, and other notified corporate persons. It forms the core of corporate insolvency resolution. Key processes covered this section encompasses the corporate insolvency resolution process, liquidation process, voluntary liquidation, fast track, corporate insolvency resolution process, providing a comprehensive framework for corporate insolvency. Initiation of corporate insolvency resolution. Section 7. Under Section 7, financial creditor can initiate, typically for loans and debenture, can apply for corporate insolvency resolution process. Operational creditor are empowered under Section 9 for debt-related goods, services, and employment to initiate corporate insolvency resolution process. Corporate debtor itself can initiate insolvency resolution process under Section 10. So 7, 9, 10 are important sections to be kept in mind for CIRP, financial creditor, operational creditor, corporate debtor seeking resolution for its own solvency. What happens in Amrapali case, JP Wishtown project, they had been a failed project and they themselves declared insolvency and looked for insolvency resolution process with NCLT. So Section 6 of IBC defines who can initiate a CIRP, ensuring that various stakeholders have avenues to address corporate insolvency. This multifaceted approach promotes balanced and accessible resolution mechanism. Financial and operational creditors. Financial creditor deals with credit, has a time value of money such as loans from banks, investment in debentures, and they initiate corporate insolvency resolution process under Section 7 and have a right to participate in committee of creditors. Banks, NBFCs, bondholders initiate corporate insolvency resolution process under Section 7, participate in COC. Operational creditors involve debt for goods, services, employment, statutory dues. They initiate CIRP under Section 9, but generally do not participate in COC unless admitted as financial creditor or resolution applicant. Vendors, suppliers, employees, tax department initiate corporate insolvency resolution process under Section 9. No COC participation unless exceptions apply. Initiation by operational creditor, Section 8 and 9. Demand notice. Operational creditors serve a 10-day demand notice to corporate debtor under Section 8. Application to NCLT. If no payment or dispute within 10 days, an application is filed with NCLT under Section 9, including proof of default. So Moblix Innovation versus Kirusa Software case established that if pre-existing dispute exists, NCLT should reject the application and emphasizing the importance of genuine default. Moratorium is dealt under Section 14, no legal proceedings, suspends all actions and enforcement of security interest against debtor. No asset transfer. Moratorium's objective is to protect the corporate debtor. It is a time when no proceedings can be initiated. So no asset transfer prohibits transfer of incumbents, alienation, or disposal of the debtor's asset. No recovery actions prevent creditor for initiating recovery or foreclosure actions. So moratorium's objective is to protect the corporate debtor's asset, ensuring a smooth and unhindered resolution process. This period allows the formulation of a viable resolution plan without external pressures. Committee of creditors is provided under Section 21 of IBC. Composition primarily includes financial creditors if non-operational creditor form the COC. Approved resolution plan requires minimum 66% voting share for approval. Replace resolution professionals can replace resolution professionals overseeing corporate insolvency resolution process. Decision to liquidate. COC has power to decide on liquidation of corporate debtor in case resolution plan fails. So there is a case, Esser Steel case 2020 upheld the primacy of COC in decision making, underscoring its crucial role in insolvency resolution process. So COC ensures that interest of creditors are central to the resolution strategy. Distribution of assets. Whenever there is a resolution process approved or liquidation comes to picture, there is a waterfall mechanism provided under Section 53. If resolution fails, then what happens? Liquidation under Chapter 3 is provided. There is a waterfall priority when it comes to liquidation of the asset is concerned. So insolvency resolution process cost is first to be disbursed. Workmen's dues 24 months plus secured creditors opt out. Wages and unpaid dues of employees 12 months. Unsecured financial creditors. Government dues 2 years plus remaining secured creditors. Remaining debts and dues. Preference shareholders and equity shareholders comes at last. Liquidation process is provided under Section 33-54 when is liquidation ordered. COC rejects resolution plan, committee of creditors. No resolution plan within 330 days is arrived out. Resolution plan violates Section 30, subclause 2. Debtor contravenes approved plan. The process is liquidator is appointed, public announcement of claims, liquidation estate formed, an asset sold, distribution under Section 53 as per waterfall mechanism in the previous slide has been explained to you. Company is dissolved. The case is ABG Shipyard among first large liquidation cases under IBC. There is a summary table for you to keep the bullet points. Applicability of the code, Section 2, corporate persons, LLP, individuals. Initiation of corporate insolvency resolution process. It is provided from Section 6 to 10, Section 7, financial creditors, Section 9, operational creditors, Section 10. Demand notice, Section 8, 10 days notice before, Section 9, application to NCLT. Moratorium, Section 14, legal freeze on proceedings. COC is 21, decision-making body of financial creditors. Liquidation waterfall provided under Section 53, hierarchical payment distribution mechanism. So with this, I would end here. Happy learning.